2024, the year in review, then 2025, the year ahead of us. I want to talk about 2024, the year in review, what we were able to accomplish, some of those challenges that we had, and then probably in the next video, I'm going to talk about the year ahead of us, 2025, and how to prepare. As you know it, my name is Bijoux Ngwanda. I'm an immigration lawyer based here in DC. However, I do have clients across the country and around the world because we are dealing with complex U.S. immigration law cases. If you're new to my channel, please go ahead and subscribe. If you are not new, welcome back. Thank you for subscribing. And please do not forget to hit the notification bell so you don't miss out on anything. If you enjoy the content, you go ahead and share, like. Don't forget to comment below. Also follow me on all platforms. Links are in the description box below. 2024, the year in review. What's happening in 2024? What happened? What's still happening? Because we still have 4 days to go. Well, we had a lot of challenges, but because we were prepared to respond accordingly, and we were able to meet some of those challenges, and some of them, sorry, I haven't talked in a while, you can see, right? And some of them we haven't been able to meet those challenges because, the nature of the job, you do not win every cases. However, you mitigate, the one that you do not win. There's always a way to mitigate those circumstances, especially if you are in removal proceedings. Number 1, prosecutorial discretions, okay? When it comes to prosecutorial discretions, the Dolly memo had laid out some priorities, guidelines, basically enforcement priorities. According to the memo, we had 3 categories of priorities. If you fall into those 3 categories, most likely prosecutorial discretion is going to be denied, and you really have to have mitigating circumstances or factors to allow the PD request to go ahead and be granted. Basically, you have to be able to convince ICE, right? So we had wins, of course, as usual. We had wins in prosecutorial discretions, especially in Baltimore. They do respond within 2 weeks. They had really gone better in responding within 2 weeks. We had wins on those areas. We were able to reopen cases that had removal orders dated 20 years ago, and terminate those removal proceedings, and adjust status with USCIS, and currently cases are pending with USCIS, which we know for sure those green cards are going to be granted, because we can tell, right? There's no other inadmissibility issues. And then we had some cases where we were not able to get prosecutorial discretion. Why? Because of priorities guidelines. Okay, but I want to talk about 2 where it wasn't a priority, but it was pretty much similar, and now I understand why it was really denied. Well, volunteer departures. Well, when a person has been granted volunteer departure, that person has to leave, right? Within the time allocated by DHS, you have to go. If you stay, then you'll be barred from adjusting status for 10 years. But then the thing is, even after the 10 years, when you come back, once you have I-130 approved and you want USCIS to basically grant you that I-130, sometimes USCIS is, you have I-130 approved, and you want now us to grant you that prosecutorial discretion so you can reopen your case, right? Sometimes it doesn't work better because of the prior volunteer departure that you agree upon. So we had challenges in those areas. Those similar cases got the same response: deny, deny, deny. So what next? we had to reopen the case in terms of filing a motion to reopen directly with the court, currently pending. Hopefully, our argument is going to stand, the test of time, and hopefully it's going to get reopened. But the reason why it was denied is because of that volunteer departure that wasn't followed. Well, not all volunteer departures get basically denied in terms of PD request, because we had a person who had a order of removal in absentia, failed to show up in court, but still the PD request got granted. So basically it's case by case basis. But what I find out is that the similarity is in those two volunteer or departures cases, both of them in separate jurisdictions got denied. And I asked around with other colleagues, they find out too the same thing. The people who had volunteer departure and never departed, their PD request got denied as well, in terms of the other people that I asked to just see if there was a trend, right? And we came to the conclusion that when a person has agreed to take volunteer departure, well, it's either you just don't agree to it and go with the order of removal, or, apply for, appeal the case with the BIA and go all the way to the federal court, circuit court. But the thing is, if you agree to depart and you don't depart later on, challenges that you'll face ahead are pretty huge. That was a trend. I saw it across lines, across states, across jurisdictions. It just was not working well for those type of individuals. That's what I've seen as far as trend in 2024. But the good trend was that people with order of removal that did not take volunteer departure, and some of them were into priorities, but we were able to mitigate some circumstances and get that joint motion to reopen case and, terminate those old removal cases. And then now we can adjust status with USCIS. So those two things, just be aware of that as we go ahead in 2025. So another challenge we got. What was the challenge? The challenge is with master hearings, okay? When it comes to master hearings, basically you have to be able to deny allegations and charges. Don't concede on those removability charges just because it says so. If you don't agree with the judge, if you don't agree with the notice to appear, you have to deny those allegations, and you'll be given an opportunity to file for an appeal. Basically, preserve your right to appeal on those specific issues. The challenge that we face is because those other people, when they previously went to their master hearing, they did not deny those charges. Basically, they considered those charges, and now it's difficult for them to appeal unless you can file basically what we call ineffective assistance of counsel, so that you can repair that mistake because probably you didn't know and you were not canceled properly. And there are procedures that you have to follow in order for that claim to stand the test of time. That's a challenge. We've seen it in 2024, and we just want to tell people ahead of time as we go into 2025, because USCIS will be referring those cases to court like like it was back in the days of 1.0. They will deny, refer to court, deny, refer to court. And once you receive that notice to appear, pay attention, really closely attention, to know whether or not the allegations that are contained in the notice to appear are correct. If they're not correct, don't just agree. A specific example was, we had a case that has been transferred to, referred to court. We have a master hearing. I was looking at those allegations. It says that the person got here without inspection, which is not correct. That person came here with a visa, actually twice. The first time with a diplomatic visa, diplomat, and then the second time again with the diplomat visa. But the allegation says you came without inspection. We have to deny it, because to allow that person to adjust status later on, if they find a way to adjust either through marriage or to, immediate family member. So we have to pretty much deny those allegations and then provide evidence to that effect. So that's a second trend, really, that you have to pay attention on master hearings as far as those allegations are concerned. And the third trend, probably the last one for 2024 as far as challenges are concerned, is basically when it comes to employment-based type of visa, okay? Employment-based type of visa, you have to make sure that when you file for adjustment of status, you have to be within lawful status in order for that employment type of visa to work. If you are not within lawful status, adjustment of status is not going to work unless you meet the requirements. We saw a trend where the people were supposed to be where they were actually paroled, but because they did not claim that parole, the parole was valid for 1 year, and they had an opportunity to be sponsored by their, employer, but they failed to do so because first of all, they didn't even understand that they were paroled, and the parole was valid for a full year, and they could have been sponsored by the employer and getting a type of adjustment of status based on employment, because remember, you have to be either admitted, inspected, or parole, right? And because they were paroled for humanitarian reason, so they have a valid type case of adjustment of status, and the parole was valid for 1 year. Some people had parole valid for 2 years, but they failed to understand the validity of it and the purpose of it, and they couldn't file adjustment of status within that 2 years or 1 year validity of their parole while they were still within lawful status, and they missed their chance. Now it's just a matter of, are you going to win asylum in court? You know what I mean? Are you really going to win asylum in court, because the case is pretty much referring court, and are you going to win it in court, which is really difficult. So that was another trend of challenge or mistakes people made, and now we're facing those challenges based on other people's mistakes because they failed to realize something really major. So those are the challenges, the year in review for 2024. I've seen a lot of trends, but those were really keep coming, recurring. So I had to make videos. I have to make this video, or I'll make other videos about those 3 challenges, complexity that we were able to face and meet those challenges, and some not. We couldn't because, it was kind of too late. But again, mitigating circumstances in court, hopefully it's going to allow us to win and stuff like that. So this is it for this video. 2025 is coming. I am reframing myself from talking a lot about this upcoming administration, because I don't want to just base my videos on speculation alone. We want to be able to have something concrete and be able to discuss based on something concrete. However, some topics, because they're just coming, they keep coming, I'm going to address them before 2025. But when it comes to Trump policies and, everything that's going to happen in 2025, how about we just wait for January 20th, because he's going to start signing executive orders from day one, and then we'll have something concrete to discuss about, and, the course of action that people will be taking and the challenges that he will face in court too. So we will have plenty of time to discuss based on something concrete, the evaluation, the evolution of all those court because there'll be lawsuit after lawsuit and stuff like that. So then they just hold on for a minute and just, wait, and then we'll discuss. But I'm gonna come with the second video just to outline two major topics that keep coming in the news and stuff like that, so we can just elaborate more on those. Meanwhile, if you need a consultation, my friend, please consult, because what's happening is that people do not do it, then they get a denial, then they get a request for evidence, then a denial even after a request of evidence, then come back to consult after just wasting their money and time. Do it before it's too late. We prefer that you do it before the filings. You can also do it in the middle of the filings. Consultation link in the description box below. Until next time, bye-bye.